Get ready. 5 seconds. 2 seconds. Start. The opposite party filed the written statement denying the allegations, contending that after getting married they lived separately and did not live with his parents. The allegation of demand of dowry was denied and the incident dated 24th March 2006 was also denied in the manner in which the appellant had alleged. According to the opposite party, the appellant went to her parents' place during Holy Festival where she was pressurized not to go back to her husband's place, and when pressure was exerted she consumed poison. The opposite party contended that when he was informed, he rushed and took the appellant to the hospital and got her admitted and took steps for her treatment, but after 2 days, the parents of the appellant took her away from the hospital while the opposite party had gone out to purchase medicines. In this regard, the opposite party sent a telegram to the SSP. It was also stated that during the course of mediation, the appellant's parents' inconvenience with the police forced the opposite party to consume poison at the police station, as a result of which he was hospitalized, and that the police lodged a first information report against him. It was also contended that the opposite party made efforts to bring the appellant back to his house, and when all efforts failed, he filed an application under Section 9 of the Hindu Marriage Act for restitution of conjugal rights. As a counterblast, the appellant filed the suit for divorce under Section 13 of the Act. The trial court, after sifting through the evidence, allowed the application for restitution of conjugal rights and directed the appellant to live with her husband and perform her marital obligations. By another order, the trial court dismissed the suit for divorce. The appellant, being aggrieved by the aforesaid two orders, has filed two separate appeals which have been clubbed together and are being decided. The trial court held that the parties had a love marriage and that they got married after running away from their parental home, and that the parents were not involved, and therefore the question of demand of dowry from the side of the husband's parents did not arise. The court below disbelieved the theory of dowry as raised by the appellant, contending that if the opposite party had raised a demand of dowry immediately after the marriage, in which case the marriage would not have been registered. The trial court further found that after marriage the couple were living separately and that the appellant was not living with her in laws, inasmuch as the appellant could not remember the size of the room or the effects inside the room where she was staying, not could she remember or recognize her sister in law and other members of her husband's family. The trial court held that the appellant could not prove that she was living with her in-laws. The trial court also held that the divorce suit was filed after the application filed under Section 9 of the Act for Restoration of Conjugal Rights. Full stop and over.